Let's go into it. The key events that got us to here, and as Ian said, it's taken quite a while to get here. It's not just sort of jumped on, like it's not just happened all of a sudden. So the Climate Change Act 2008 came out in 2016. The UK ratified the Paris Agreement to the United Nations Framework Convention on Climate Change. What that basically meant was that we were going to hit certain targets by 2030 and 2050 on our climate emissions. We're not on target for them, which is a shame, but it was the start of us starting to think about how do we lend, how does our stock, our housing stock, matter in terms of climate change and emissions. October 21, the Law Society brought out a resolution, and then 2023 they brought out a guidance note that was for every single solicitor, and I'll talk a little bit about that, but I think we can happily not forget about it, but we can focus more on the practice note moving forwards. I wanted to say the interesting thing in October last year, and it's even more now, 80% of our clients adopted into climate change. We don't force climate change into any reports. We ask you whether you want it or not. So we did see people were being very active even before the practice note came out in just putting it in there. So I'm not advocating for you to put climate change in there, but it's interesting to see that people have just decided, you know what, we'll put it in. That's probably the best way to go, and I'll talk a bit more about why you might want to. And then November, the consultation came out. There wasn't as much kickback as I think people were expecting. I think possibly there was a bit of preoccupation with the TA6 that was happening at the time. So this, I don't think it deliberately went under the radar, but I think a lot of people were sort of going, well, so it didn't get much response really in the grand scheme of things, and then the note was released in May, so it's been just under a month now since it got released. The guidance note, as I say, was for all solicitors and all lawyers, and it had two parts. The first part, this is the 2020 part, was about understanding and reducing your impact and your client's impact, and the second part was on climate change risks, which is then more property related. It was very vague at the time. It lent heavily on your duty of care and duty to warn, and it didn't really tell you what you should do, whether you should do anything. And this is why the practice note came out, because I think they realized they needed to be a bit not prescriptive but helpful, a bit more helpful, I suppose, in what they were trying to offer. So today, my experience talking to all the conveyancers that we work with now is generally a lot of conveyancers are leaning on the environmental providers. So they're getting the climate searches and they're using Chancery Lane's Marley clause, which Ian called out earlier. It's got some really useful commentary that can go into your reports, into your search reports on titles, and so on. And it's a way of protecting yourself without having to give much advice. Some are ignoring it. There's 20% of the people we talk to say, worry about it when I get to it. I'm not saying that because they didn't buy a climate search, they're ignoring it, but in a lot of cases, those 20% are saying, I'll worry about that another time. Others are switching after their compliance audits. That's been quite common. I get a lot of people ring me up saying, hey, can I upgrade to climate now after they've had a compliance officer come in and do an audit? And the risks that until the practice note came out, that were typically reported on in physical risks that were particularly reported on were ground stability, flooding and coastal erosion. That's changing a little bit now, so I'll talk a little bit about that too.